Thank you. My lords, just to give an indication, I anticipate I will be no more than 10 to 15 minutes.
Thank you very much. Yes.
Just before we leave the authorities bundle, one final aspect to mark up. And you'll find this in alley at tab 24, which is the jeunesse point. It's the weight to be attributed in the Article 8 balancing exercise to private life, developed in circumstances where those developing it knew it to be unlawful or precarious. This is a case we haven't added to the bundle. You may think you have sufficient authorities in the bundle already, but just so you've got the summary of it, paragraph 28 of Ali, Lord Reed, summarizes I'm looking at 4 lines down. Practice to take into account was said in Jeunesse case to include the extent to which family life would effectively be ruptured, the extent to which the ties of contracting stage to insurmountable obstacles, the way the family living in the country of origin is concerned, whether factors of immigration control or conservation of public order weighing in favour of And then I emphasize, and another important consideration was said to be whether family life was created at a time when the persons involved were aware that the family life within the host state would from the outset be precarious. Where this is the case, the court has said that it is likely only to be in exceptional circumstances that the removal of a non-national family member will constitute a violation of Article 8. And then I won't take you to it, but just so you have the reference, the jurisprudence is summarized again at paragraph 75. Special matter.
Thank you.
That then brings me to the points, the grounds of appeal. And there, so the first ground made against me is that the judge erred at paragraphs 26 and 27. My submission, as set out in the skeleton argument, is that it's important to be clear what submission the judge was addressed with and what he responded with and why. Paragraph 26, the argument is framed that the legislation on the public interest in deporting foreign criminals excludes from its scope foreign nationals convicted outside the UK. It follows that those convictions do not carry as much weight as a conviction in the UK when assessing the public interest in deportation. That is a submission that the judge disagreed with. And in the following paragraph, he gave lawful and accurate reasons as to why he disagreed with it. In summary, and this is ground travelled this morning, because one, the fact that a crime is committed within the United Kingdom, which falls within section 117C, shapes and frames the Article 8 balancing exercise conducted in the context of offences which fall within that framework. I think it's appropriate to add that 117C, read carefully, in parts gives things and in parts takes them away. In parts it's slightly less onerous than the Strasbourg jurisprudence because once you satisfy that there are unduly harsh consequences for individual children, for example, the seriousness of the offence doesn't then come into play in relation to the medium offenders. But overall, I accept 117C imposes onerous requirements, and moreover that this court has repeatedly said that one of the factors bearing on the balancing exercise in 117C is the statutory imprimatur that applies in respect of that provision. The balancing exercise to be conducted where the offence has been committed abroad is a different one. It is a balancing exercise which places all the multi factors into the scales and determines, after that balancing exercise, whether deportation is disproportionate, having regard to the family and private life interests identified. It is not a particularly helpful intellectual exercise in the context of that balancing exercise to ask oneself, what response would I have given to this particular application had it fallen within section 117C?
Not helpful.
It is not a particularly helpful exercise because that is a differently framed balancing exercise. Rather, the test to be applied, as the tribunal correctly directed itself, was an unvarnished Article 8 balancing exercise.
Yeah.
And just to illustrate the problems if one tried to do a comparative exercise, my learned friend's case, at its highest, suggests that because certain sentences come within the framework of 117C, that means they are intrinsically graver or intrinsically to be given more weight in an Article 8 balancing exercise than those that do not. But 117C contains a spectrum of offences, some of which start at 12 months. Even the serious threshold starts at 4 years. If my learned friend were right, where does one, and in effect, 117C places a ceiling to which one should have regard when factoring into an Article 8 balancing exercise any offences committed abroad. Where does one put offences of the seriousness of this case, or the murder conviction in CK, into the scales? If we are artificially comparing across and seeking to have, in a way, an upper threshold of 117C, saying it can never have the same weight in the abortive balancing exercise, it can never be considered as serious as a notional domestic offence, because it doesn't have the additional substructure and the additional...
So you could never treat a murder abroad as serious or more serious than a fraud that got you for 4 years?
Yes, and you have some of the cases in the bundle which illustrate how that difficulty comes in. But I'm not sure that my learned friend places his case that highly. But if one were to adopt, in effect, 117C as a ceiling, which regard should be had in terms of how the public interest plays, that would be one of the absurdities that would arise.
Forgive me, Mr. Stoneman,
Yes.
maybe I'm being stupid. I'm not sure I really understand the point about treating section 117C as a ceiling.
Yes, I mean, this is one reading of paragraph 26.
Because 117C2 makes it clear that the more serious the offence, the greater is the public interest in deportation. So if you're getting a longer sentence than 4 years, it doesn't mean that the weight stops at 4 years. And perhaps I'm misunderstanding the point.
No, not at all.
Floor, not a ceiling.
Yeah. The, if one accepts the submission,
Yeah.
117C,
Yeah.
offences within 117C are intrinsically to be considered more seriously than offences committed abroad.
Yeah.
Yes.
Then one could have a scenario where the tribunal is considering serious trafficking or violent offence abroad, with a sentence of 7, 10 years, 12 years.
Yeah.
And it is constrained because the offence was committed abroad to give it less weight than those offences which are caught within
Oh, I see what you mean.
117C.
Which could range in seriousness from a sentence of 12 months to life imprisonment.
Yes.
Yeah.
Which is why my submission is that it assists if one doesn't try to overcomplicate this aspect.
Yeah.
And when one isn't in 117C territory, it's not a particularly helpful exercise to do comparisons.
Yeah.
of
What
offences.
should you do? You should say, how serious was this offence, looking at the facts, as far as you know them.
Yes. This is where we started with my submissions. Seriousness of the offence is one of the votive factors to be brought into the equation. Another factor potentially to be brought into the equation is a statement of policy made by the Secretary of State as to how a particular offence or scenario is viewed. And the exercise to be conducted is the unvarnished balancing exercise, which was conducted by the upper tribunal in SC and which was conducted by the upper tribunal in this case.
I suppose
At the end of it, yes.
Sorry to interrupt again.
Yes.
I suppose the point about Section 117C is precisely because it's dealing with such a range of seriousness of offences. It's very difficult to point at the weight that Section 117C requires the tribunal to attach to an offence.
Yes.
Yeah. Okay.
Yes.
And on my reading, this is what the judge intended, and if there were any doubt, it's paragraph 36 where he refuses permission to appeal. He says the first ground is not arguable because the upper tribunal adequately explained why.
Wait, where are you?
Page 36 of the bundle.
Oh, page 36. I thought you meant like 20.
This is the refusal of permission.
Can we really look at that to understand the decision? Everyone does, but
Well,
is it something here's what I prepared later?
Yes,
It-
on
it does.
reflection, having seen the grounds of appeal, this is what I now think.
Anyway,
Well, you will-
you want us to read it?
you will take that with all the requisite pinches of salt that may be apposite given the timing. But
Yeah.
what the judge does say is that even though the framework applicable to foreign criminals does not apply to a person convicted of a crime outside the UK, the public interest in that person's removal may, depending on the particular circumstances, be justified.
Well, yes. I suppose Mr. Lambs would say that isn't what the tribunal actually said in giving its decision.
I say that's exactly what it said, or what it intended to say in its decision,
Well, which?
which it is.
Well, I suppose what you say, it's what if you read the decision as a whole, that is in substance. That's a summary of the intellectual exercise which the tribunal engaged in.
Yes. And it
I still
says,
think we've actually got to read the decision. I mean,
Well, of
the
course you
person
have.
who said is
Yeah.
dealing with the decisions determinant. If the decision doesn't mean that, I'm not sure, or doesn't read
No,
like
obviously not. The decision doesn't mean that.
I mean,
It doesn't help us.
exactly. But
I mean, I get the same assistance from the upper tribunal, the presidential panel's balancing exercise that we looked at a moment ago, where the point was made that the public interest in the context of this balancing exercise is not a fixity. In other words, once you're outside 117C, it becomes necessary to conduct a fact offending specific unvarnished Article 8 balancing exercise.
And in those circumstances, is it right that the appellant must show unjustifiably harsh consequences?
The choice of language in my submission, it's not appropriate to be overly prescriptive about.
Well, doesn't the phrase must show unjustifiably harsh consequences? Is that not overly prescriptive?
As a means
Because
of,
it ties it to the framework in a way which we've agreed is not appropriate.
with unjustifiably harsh consequences is not something derived from 117C.
No, that comes from the
Guidance.
Article 8 exception in the immigration rules. doesn't it?
Yes.
Which is, it's one way of expressing that the consequences of deportation must not be disproportionate. That's why it appears in the judgment in Agiaku, which you have in the bundle.
Yeah. Okay.
That's why it appears in the immigration rules in Appendix FM.
Okay. So that phrase, the importance of that, of course, is that is the phrase that appears in the quotation from SC, which is cited in paragraph 34B of the judgment.
Yes.
And by aligning the approach with that approach, it's not the same as bringing it within the Section 117C framework.
No, and if you want to see the contrast, if you cross-refer and check the exercise conducted by the first-year tribunal in this case, which did think that 117C and the immigration rules provide, you'll see a very different exercise. It's going through the exceptions, it's repeatedly emphasizing the statutory imprimatur. That is not the exercise this other tribunal conducted.
And in any event, even if you are within Section 117C, Section 117C2 makes clear the weight that's to be given to the public interest will vary according to the seriousness of the event.
Yes.
So really, you say the balancing exercise conducted in the event by the upper tribunal 34, 35, 36 does not fall foul of does not fall into the trap of aligning it,
No.
tying it to the framework of 117C.
In my submission, it entirely doesn't tie it into that framework, and in fact it is an exemplary balancing exercise which looks at all the relevant factors. It lists first the problematic immigration history and the maintenance of the lie on which the individual came.
Well, we've read it.
Yeah. Secondly, the seriousness of the crime, the circumstances. Third, the UK offences disregarded. And then also in terms of proceeding along the path that the statute requires, you'll see paragraph 35, 117B.
Yes, there are several references to the factors set out in 117B, aren't there?
Okay. There's then paragraph 36, factors going the other way. And the conclusion reached, paragraph 37, was that even taking Mr. Horrocks' opinion on the negative effects of the appellant's deportation on his wife and children at its very highest, I am satisfied that the very substantial public interest in the applicant's deportation outweighs the factors weighing in his favour.
It's not expressed as 117C, that paragraph.
No. Nor is the next sentence the language of 117.
No, I was reading the whole of the paragraph.
Yeah, it's the language of Agiaku in the context of spouses that overstayed.
Thank you.
So in fact there are 4 references to 117B in two references in para 35 and then references in 36B and C.
Yeah, that's right.
One more point, which I think was made more forcefully against me by Lord Justice Lewis rather than my opponent, but which is still important to address, which is the SEC 1.4 point. And there, just so I've addressed it, you will see reference to SE 1.4 is in paragraph 27.
Yes.
The assistance there derived from it is that in SE this was considered. It was noticed that the immigration rules concerning entry clearance provide for the exclusion of applicants when convicted of offences in the UK because it's conducive, outside the UK because it's conducive to the public good. So it gains a degree of assistance there. And then in paragraph 34B,
Yes.
The tribunal says it's none of the less a factor that weighs heavily against him, and that is the serious crime, the proportionality assessment. I note that the appellant's position is similar to that, paragraph 94 in SC. It was stated that because the individual unlawfully entered the country, had never received some assistance was derived from the rules on entry clearance. This individual is arguably in a worse position, where we're forever being told that we shouldn't do comparisons across. This individual secured his leave by deception. And therefore, in my submission, there is a real question as to whether and if so why he should be in a better position than an individual applying from abroad. Those are my submissions.
Thank you very much.
Anything else? Thank you very much. Mr. Lambs.
My submission is that, well, following on from my previous submission, that there is what's happening at paragraphs 26, 27 and 28 is that the judge is having regard to that very high threshold that applies under the 2002 Act, saying it's not reduced in principle. And I think that is actually what the argument was in SC, that in fact the higher tests that applied that mirrored section 117C still apply, notwithstanding that it's a foreign conviction. And I'm looking at SC at tab 28, paragraph 77. I mean, it's important to see the background to how it was argued in SC. In SC, they're looking back to the submissions made in MW. And the submissions in MW are again that you can get to an equivalently high standard through as part 5A, or as it was then, the rule through 398 to 399A, because they had, although the wording was slightly different in the pre 2014, they had the same basic structure of undue harshness and very exceptional circumstances instead of very compelling circumstances.
Is this a reply? What point in Mr. Thomas' submissions are you addressing now?
Well, I'm addressing what SC actually engaged with, and is it all about a lower standard, i.e. unjustifiably harsh, viewed through the lens of, I don't know, Aguiarco and those immigration cases, or are we actually saying that we're actually still very much in 117C territory? And I mean, you've got the phrase unduly harsh at 94 of SC, but you've also got 140.
We can pick sentences out at different stages from the judgment. Start with what you tell me this judgment actually decided. What legal principle? What's the ratio descendendi in the old words? What has it decided?
Well, I think it decided. Sorry, the SC.
Yes.
Well, I think at 71 it decided in relation to the immigration rules that the immigration rules.
Yeah, that's what it decided. That to
Yeah.
foreign and criminal, it doesn't mean you've got those two qualities. It means you've got to be foreign criminal as defined in the Act.
Yes, that's right. But when it was what I'm looking at this case for is to try and put in context paragraphs 26 and 27 of the upper tribunal's decision, because this case was argued in front of him. He makes reference to it in his judgment and in paragraph I think 27 itself, And what I think the context of it is that the Secretary of State in NW, it's set out at paragraph 77 of SC, it's page 13 of tab 28. The appellant in that case was the Secretary of State. So you have it 32 indented. The appellant goes on to submit that there is an equal weight to be attached to the public interest in refusal of entry under the provisions to that which arises under 398 and 399A. So that's the onerous.
I'm so sorry, it's my fault, Mr. Lambs. Which paragraph are you reading from?
I'm looking at page 13 of COCAT.
Which paragraph, please?
Paragraph 77.
77, thank you.
And
Where there's a citation from MW.
a citation from MW, and the point I seek to draw out of that, in MW the appellant was the Secretary of State. So the Secretary of State's argument there was actually the onerous regime that 398 to 399A was the mirror of Part 5A, 117C, with all the exceptionality provisions in it. That you got the entry clearance provisions imported that same standard. Not a lower standard Agiarco and immigration laws, but the high standard, the elevated standard that I've been talking about earlier this morning, and the in the Court of Appeal agreed with that. They said yes, we would, because the respondent, that was the applicant, was arguing against this proposition. But at 35, Ms. Revel for the respondent was arguing against.
It's almost certainly my fault, but I have a real problem lately with this habit of taking a sentence or a paragraph out of context. I can see that 77 recites what the Court of Appeal says, and I understand that what you're trying to do is to marry paragraph 27 of the tribunal decision in our case to say that when it used SC, it was a shorthand for something that you find objectionable, which is treating it as equality. But that was part of the decision of the court when they were getting to its decision. And if you look at 79 onwards, where they actually come to this, and the factors that they're dealing with, is there anything in those parts?
Sorry, 79
of the SC case. Is there anything which says that this case, as opposed to the extras that is quoted from MW, was saying that you've got to have the equal in necessary compelling circumstances approach?
Well,
in what it actually decided.
When you get into the balancing exercise, it's multifactorial, and what's important is your starting point.
I understand all of that. Mine is a factual question.
Yes.
To save me reading at quick speed, 30 paragraphs, because you'll have read all of this before you came to court. In paragraph 79 to 114, where is the paragraph that you say clearly ties entry clearance to unjustifiably harsh, or whatever test you want to use it, and which then ties into paragraph 27?
Sorry, you're talking about SC here?
Yes.
Yeah.
Well, as I understand your case, you're saying tribunal judge in our case refers to SC. You've taken us to one paragraph, which is a citation, which you say shows the objectionable thing, and therefore you're saying the tribunal judge must have meant the same. And I'm just asking you, where in paragraph 79 onwards, when we seem to get to the meat of the decision on balancing, the judge of the SC tribunal says that?
114 says that they fail by a significant margin to show it would be unduly harsh on each and all of them. That is indicating that it's a higher test, because the undue harshness test doesn't have a place in the.
But that's the phrase that you're objecting to. Then that's where you say SC.
I'm saying that indicates. That indicates what's happening. But what is important is at 77 and at 35 of the quoted case, we're not moved by the argument advanced on Rebel about the source of 1.4. And it says that, so it's talking about 1.4, the provisions represent an authoritative statement of public policy broadly consistent with the 2007 Act and the new rules. And the new rules in this is a reference back to 398 and 399A, which is the harsh deport rules that are now 117C. So that's a clear link that's been quoted there. And we, at 37, they set out, in our view, the intention behind SEC 1 was emphasise maintaining refusal and consistent with approach in deportation cases, very compelling reasons will be required to outweigh the public interest in deportation. We consider that the policy must carry similar weight, and the emphasis on the phrase very compelling reasons is appropriate. Very compelling reasons is the wording of 117C6. So we have there the logic of this is we're reading across a very high standard. We're doing it through the medium of SE 1.4, but we're identifying what is the strength of the public interest. And of course, if one's looking at the structure 117C, it's basically, if you get to 4 years, you need an extremely high Article 8 test to defeat it. And so 4 years is almost a cliff edge, and it's not just incremental, it's step. And so in this sort of case, we're saying, well, if you apply that structure and that reasoning to the appellant's case, then you are importing a very high standard. And that's why I've taken you to this case, because I think when you look at the upper tribunal's decision in 26 and 27, he's quoting from SC, which in turn takes its logic from MW. So, I mean, and that is, I mean, my left friend said, you know, well, it's not a helpful intellectual exercise to start comparing one with the other. But of course, that's exactly what the criminality guidance says you should do. The Home Office own criminality guidance. They say you should use the 117C as the guide when you're looking at these non-overseas, when you're looking at these overseas.
Well, do you accept that MW is, if not strictly binding on us, it's an authoritative analogy?
Strongly persuasive.
Well, thank you. Strongly persuasive.
Well, it may be persuasive, but it's the point I'm saying is that you know, it goes back to how are we construing what the upper tribunal judge actually said.
Can I just mention one thing about SC, which is
Yeah.
paragraphs 96 to 97 of the determination of the upper tribunal. The crime of which the appellant and SC have been convicted was murder. And you see in paragraph 96, the upper tribunal saying, for example, murder is one of the very gravest crimes that be committed in any human society. Its significance is much less susceptible to diminishment over time than in the case of other offences. Third is case on stance of remorse is hopeless. So, and then in paragraph 19, for these reasons, the public interest in deportation is undiminished. So, I mean, are you suggesting that because the upper tribunal in this case referred to SC, the upper tribunal was adopting the same approach? Because it can't have been, because it's a different offence.
Well, what I say is that my submission was framed along the lines of if you're applying the 117C structure, obviously it will depend on how it's applied. Will depend on the length of the offence. I mean, even 117C has that provision, as Lady has actually pointed out, highlighted today. But that's not to say that a 4-year sentence under 117C is that attracts all the statutory direction as to only allowing this in a very small minority of cases, etc., etc. We have in Hesham and we have in all the other cases. So you get the full force of it when you get to 4 years, but that's not the case. Not necessarily the case when you get to.
Well, you don't get the full force of it when you get to 4 years, as is obvious from the drafting of 117C subsection 2. Well,
I mean, if it was purely incremental, then one wonders really why it's there. But I think it is a step approach that you need the very compelling reasons, and the extent to which you could chip away at that high test depends on your facts. But the bar is set at, I wouldn't say uniformly high, but at an incredibly high level when you get to 4 years. And that's why, if you had undue harshness, that would be all right for the claim to succeed up to 3 years and 11 months. But when you get to 4 years, you've got to have undue harshness plus plus. If you're talking about, family life. So it is structured in a step.
But so what's wrong with the approach of the upper tribunal in SC then? Because they seem to have applied an unduly harsh test.
Well, that's my point. I think they did apply an unduly harsh test.
But they were dealing with murder, and they applied the test that Section 117C applies in cases where you're sentenced to between 1 and 4 years imprisonment.
Well, I think my point is one can draw from the fact that SC is dealing with undue harshness and a 117C what the standard that the public interest standard that the judge in our case had in mind.
Can I just clarify one thing? I'm becoming confused about one thing. I understand that one of your submissions is that if, when we read it, the upper tribunal judge in our case applied the unduly harsh test, which features in one of the subsections of 177C, you went wrong. Now, I understand that. I'm now moving on to a separate question. If, in fact, the judge in our case did not do that, but used the language of unjustifiably harsh consequences, which are used in connection with the rules on entry clearance, would the upper tribunal judge have gone wrong if he used words such as unjustifiably harsh consequences?
Well, I mean, unjustifiably harsh consequences, I mean, is typically a phrase that relates to Article 8 non-criminality. But I think it's capable...
Such a yes or no question,
well,
actually.
Sorry, I think it's capable of covering, in a loose fashion, criminality cases. I mean...
so if the tribunal judge in our case used language of unjustifiably harsh consequences, would that be unlawful or not?
If he meant by that, I'm not applying the same high standard as applies in 117C, then that wouldn't be unlawful.
Right.
But my point is that it's clear from the preambular bit and the 26 and 27 that he clearly had in mind that a higher standard was going to apply.
Because what Mr. Tobin says and what you're replying to, Mr. Tobin's submission, as I understood it, was that although the words in paragraph 114 are unduly harsh, if you read the judgment as a whole, what it really meant was unjustifiably harsh. And at 94, that's precisely what they say the test is.
94
of SC.
Yeah. Well, in 114 it says unduly harsh.
Yes, I know that, but the submission that you're supposed to be replying to is Mr. Tobin's submission.
Yes.
That although the words in 114, and I wrote it down, say unduly harsh, when you read it as a whole, it's a sleight of hand or a misstatement of the phrase unjustifiably harsh. So I've been trying to look at the paragraphs. If you look at 94, that seems to be saying that the test in the context of the entry clearance rules is unjustifiably
And that's the
harsh.
passage which the judge in this case cites in paragraph 34.
Yeah, and you've just told us that wouldn't be unlawful.
Well, it depends on what
Well, your case
context
is, just to
made.
I mean, I think we've covered this ground, but as I understand your argument is that looking at the judgment as a whole, it's the judge was applying the unduly harsh test.
Yeah.
Had he clearly confined himself to unjustifiably harsh consequences, you wouldn't have had a complaint.
No.
Because that wouldn't tie it to the framework.
That's right.
No, look, your case is looking at it as a whole, as one must.
Yeah.
It's clear the judge was attaching it to the framework, thereby fettering his discretion, and so you invite us to allow the appeal to remit the matter so the upper tribunal can have another go.
That's precisely it.
Yeah. Okay.
And I say what gives the lie to this unjustifiably harsh meaning of purely Article 8 non-criminal is actually the reasoning that came before it and the submissions that they're looking at, and they're looking at a submission that you get to the very severe deport rules through 1.4. They're not talking about sort of just a private, without status situation, not having legal status. The unjustified harsh is typically used, as I accept when I've read Agiarco type cases. You know, you have a marriage application or you don't meet the financial criteria. And then you go on to ask whether it's unjustifiably harsh, you know, or insurmountable. It's aligned with the insurmountable obstacle test. But these phrases are often not used particularly clinically, I would say. I mean, if you go back to MF Nigeria, there's you know, the language varies between exceptional circumstances and unjustifiably harsh circumstances, and you know, are these terms of art, or you know, in some ways they should be terms of art, because undue harshness means a specific thing because it links into 117C, where so I mean it's I think so. What I was saying is important is what were the principles? What were the how was the public interest graded going into this exercise rather than the language itself? And I think just one final point in relation to the upper tribunal's reasoning and how one actually looks at it.
Yep.
26 and 27, he's rejecting my point of principle.
Yes.
28, he's saying, well, you know, I read that sequence between 26 and 28. He's saying, Mr. Lambs is wrong about, you know, the standard not reducing the public interest, but at 28, there might be some wriggle room, notwithstanding the very high standard, and that relates to, you know, things about particular issues that might arise in relation to a foreign conviction. There might be some circumstances, you know, if the conviction was for an offence that we don't recognise, etc., etc. But I would suggest that the proper reading of what the judge is saying is that the starting point is that you do equate the overseas conviction with the domestic conviction, and then you could chip away if you need to TEP 28. And I think that is actually consistent with the reasoning in SC.
Thank you. Anything else you want to say in reply?
Just in relation to Ali, this is the point about. I mean, under it's tab 24 and 32.
Yep. Yes? I think Mr. Toman took us to paragraph 28.
Sorry, maybe I'm wrong.
Tab 24.
Sorry,
In your authority.
sorry, it's a point I'd set up my skeleton. Maybe I misread it. 32. Whether situations analysed in positive or negative. Yes. Whether situations analysed in positive or negative terms. One has to apply the full human rights standards. So this goes back to the appropriateness of using the entry clearance criteria in the first place, or at all, because the Article 8 structures apply. When you're here, and there is a difference between, even if you're here unlawfully, you're still, if you've got, what matters is whether you've got family and private life in the UK or you don't, and it's well, that's just a short point. Those are my submissions.
Thank you very much. Well, we're very grateful to both of you for the way in which you've argued this case today. We're grateful to you for the written submissions, and also to those who instruct you for the way they prepared the case. We're going to take time to consider our decision, and in due course you'll receive a draft judgment, which will be the opportunity for you to correct any typographical errors or other errors of fact. You'll bear in mind that the judgment is circulated for that purpose only and is not to be published or used inappropriately in accordance with the guidance given by this court recently, which I'm sure you're both aware of. When we send our draft judgment out to you, we'd also like, please, you to draft an order setting out any consequential orders as a result of our decision, so that we can make that order when judgment is handed down in due course. The hand down will be in accordance with the new rules. It will be done remotely, so there'll be no hearing, no need for any attendance. Thank you all very much.